Hi everyone, welcome to my presentation. I appreciate this opportunity to be with you here today. The subject of my presentation is Beyond the Paradigm of Animals as Things, Special Treatment of Companion Animals in Chinese Judicial Judgments. Human emotional interests are receiving increased attention and legal protection, including human emotional interests towards companion animals. I think many people are aware of the significant changes regarding pets in the newly revised Spanish Civil Code of 2021. Spanish civil law and judicial practice take into account the special emotional connection between people and pets, and also give pets some special treatment which is different from ordinary objects. Then, what is the situation in my home country, China? I did a research to examine how the human pet emotional connection is placed and what's the position of pets in Chinese civil law and judicial practice. Relevant data shows that the number of pets, especially dogs and cats, in Chinese cities and towns reached 116 million in the year 2022. Chinese people and their pets are building an increasingly close relationship. If a Chinese person's pet suffers injury, death, or loss, will the pet's particularity be seen? Can the pet owner's emotional interests towards pets be protected? What are the applicable laws and what is the judicial practice there? Neither the predecessor of China's civil code nor the civil code itself directly states the legal status of animals. The provision usually used to determine the legal status of animals is Article 115 of the Civil Code. This article already existed in China's property law before the implementation of the Civil Code. This article states that things include immovables and movables. If rights are the objects of any real rights in accordance with any laws, such laws shall apply. This article does not explicitly state whether animals are things. In Chinese legal practice, animals are generally classified as things based on the objective-subjective dichotomy, which is the widely accepted view. So, do judges really follow this principle? In fact, I found some unexpected information in Chinese court decisions. Here I have two Chinese cases. The first case occurred in Shanghai in 2016. At the entrance of a residential area, the defendant drove improperly and hit the plaintiff's dog, causing the dog to die on the spot. The public security organ determined that the defendant should bear the main responsibility for the accident, and the dog owner filed a lawsuit to the court requesting that the defendant should compensate for the pet loss, for the funeral expenses and mental damage, etc. In the end, the judge ordered the defendant to compensate part of the plaintiff's loss caused by the accident, including pet dog loss and mental damage. On this page, you can see the best part of the judgment. Please pay attention to the words marked in red. You can see the judge held that pets are domesticated animals that are alive, sentient, and are capable of developing emotional connection and the spiritual dependence with people. The most important feature that makes it different from other common objects is that it has life and spirituality and can form personalized emotional connection, affective interaction, and spiritual support with its owner. In this case, based on 7 years of raising, the plaintiff regarded the poodle Bao Bao as a member of the family. The plaintiff did have some personal interest, connection with the pet in some aspects of his daily life. Therefore, once the dog died, the plaintiff's mental shock and pain were objectively present and also understandable. Another case occurred in Qingdao, Shandong Province, in the year 2020, which was also a road traffic accident that occurred in the community. The defendant Shaobo drove his car and killed the plaintiff's Yang Ning's dog. Yang Ning sued Shaobo for compensation of 35,000 yuan, including 15,000 yuan as mental damage compensation. You can see here the court decided that the pet dog in this case is a property with life value, and it is an object with property attribute, life value, emotional factors, and spiritual value attached to it. Yang Ning purchased the pet dog and kept it for 12 years and has years of emotional attachment to it. The pet dog has become an equivalent of a family member to Yang Ning and his family. So the death of the dog inevitably brought a mental shock to Yang Ning and his family. These two cases occurred before the implementation of the Chinese Civil Code in 2021. The main laws and regulations that the judges relied on at the time include two parts. The first is Article 22 of Tort Law, as you can see on this page. Generally speaking, the condition for obtaining compensation for mental damage is that one person's personal rights or identity rights have been infringed. In Chinese law, animals are property, so this clause cannot be applied to the injury, death, or loss of pets, because the casualties or loss of pets cannot be directly linked to the infringement of the owner's personal rights or identity interests. In other words, the tort law does not consider the situation where pets are damaged as property. However, there are such cases in practice, so the judges flexibly apply the following judicial interpretation. As you can see on this page, Article 4 and Article 8 of this interpretation are the provisions the judges usually used in such cases. According to this judicial interpretation, whether the injury, death, or loss of pets can be considered as damage to the personal rights and interests of pet owners depend on whether the court can determine that pets are special mementos of personal significance and whether the relevant infringement have serious consequences. If the answer is yes, the casualties or loss of pets can be linked with the personal rights and interests indirectly. Therefore, in cases like this, the court needs to determine the existence of mental damage and the special nature of pets, etc. Due to time constraints, I have listed the key points of the above two judges' judgments in a table. From this table, you can clearly understand the judges' key attitudes. You can see the two judges not only recognized the existence of emotional harm, but also comprehensively summarized the special nature of pets. It is particularly noteworthy that they believe pets are family members, which can be used as a reason for pets to have personal significance and strive for the possibility of pets receiving judicial protection. I think you must have noticed that there is a gap in Chinese law here. The special treatment given by the judges to pets is in conflict with the current legal provision in China. Chinese law strictly follows the paradigm that animals are objects, does not distinguish animals from general objects and property, and does not give special consideration to companion animals that have a close relationship with humans. However, in the above two cases, the judges not only recognize the emotional connection between people and pets, but also distinguished pets from ordinary objects, especially recognizing status of pets as family members. I think the existing contradictions are inspiring for China's future animal law. The emotional connection between people and pets should be a human emotional interest needs to be protected. The increasingly popular multi-species families also need to be recognized by law. The special status of pets should be seen and recognized by law too. So based on the conclusion drawn from this presentation, I expect changes to be made in Chinese legislation in the near future. Okay, that's all for my presentation. Thank you very much for watching. If you have any questions, you can contact me by email. See you. Bye.